We're here on this panel to discuss interconnection policy for the IP age, and we are going to revert to the normal Silicon Flatirons mode of having presenters and discussants. Our three presenters today in order will be Mark Cooper, Zac Katz, and Jim Speta. Our discussants are alliteratively named Len, Lynn, and Leslie. All of them are quite accomplished. Their bios are in the program, and I won't waste time on that. Now, Mark Cooper, on the way down from lunch, said there weren't enough fireworks this morning, other than Brad Feld's shirt.
I didn't say that. He said that. He said that.
Well, I was looking at Brad Feld's shirt, and I thought, I know what happened to that wallpaper in our bathroom from the 1970s. But he always livens it up. So we're going to proceed in order with Mark, Zac, and Jim, who are going to present précis of the paper they're writing for the journal. Mark.
Okay. Well, Phil has his way. He never asks me what I want to talk about. He assigns me a topic and makes me think about it, and then, of course, it's always the next big thing, so I can't blame him. I would not have been thinking as much about this. It's interesting, Jim Speta, somewhat to his dismay, wrote an article 10 years ago that I found extremely important because he demonstrated that the origin of non-discrimination was over half a millennium old. And I took that little tidbit and ran with the idea that non-discriminatory access to the means of communications and commerce are part of the basic DNA of capitalism. Simply put, the movement of goods and ideas across adequate and open highways of commerce and communications is essential to the success of the capitalist economy and the democratic polity. Mobility, which is anathema to feudalism, is the lifeblood of capitalism. Let's see. I wasn't going to do slides, but Doug Sicker had the same slide, so I couldn't resist. Over half a millennium, the principle of non-discrimination has progressed dramatically, and I use the word progressed. You'll hear it frequently. An intense period of legal activity around this principle took place in the 4 decades after the Bell patents expired, 1894 to 1934. During that period, we got the Interstate Commerce Act extended to telecom. We got an antitrust case that gave the competitors of AT&T interconnection and equal access. Go back and read the order, it had equal access. The Radio Act of 1912 brought public safety, and later the Communications Act of 1934 gave us universal service and consumer protection. I believe that innovation at the edge was added by the FCC during the final quarter of the 20th century, which was then memorialized and embraced in the 1996 Telecommunications Act. Now, this long sweep of history in the 1996 Act make it clear that half a dozen principles constitute the public service obligations of telecommunications carriers, and that those principles must be carried forward as the public switch telecommunications network is transformed into the public digital communications network. Congress got it, they understood it, they wrote it in the statute. Telecommunications and advanced telecommunications services are defined regardless of the facilities used. That's plain English, something that frequently eludes Congress. The level of activity around at the early part of the 20th century and then in the later part of the 20th century, I call part of the quarter-life crisis of industrial revolutions in a long article that I think is scheduled for the next journal. So industrial revolutions go through this phase: innovation, adolescence, slow maturity, and then as they begin to change the mode of production in society, they are asked to further the goals of society. We ask the question, how is the new mode of production going to accomplish our values? And we ask that in very violent times sometimes. But we also, in progressive societies, we expand and enhance those values. At that key moment, we advance the cause of the things we believe in. The progressive era is marked by changes in several critical ways. First, it shifted from ex post common law enforcement of non-discrimination to ex ante regulation of non-discrimination. It layered sector-specific regulation on top of antitrust, the Interstate Commerce Act and the Sherman Act. It also, as I said, recognized the importance of interconnectivity, of internetworking. The equal access principle was in the 1914 consent decree. Now, there are a number of reasons that... went too far. There are a number of reasons that this happened, but the key point is that as society, as the Second Industrial Revolution proceeded, the ability to have non-discriminatory access became more and more important. The need for internetworking became more and more important. And the ability of individuals to defend their private rights to non-discrimination was obliterated by the massive corporations that occupied the space, with the General Counsel's office, which was invented by the railroads in the late 19th century. And so we had this dramatic transformation. And the question that we confront in the quarter-life crisis of the third industrial revolution, digital revolution, is that should we carry these principles of non-discrimination, of interconnection, of interoperability, of universal service, of consumer protection, of public safety, should we carry those values forward? And I think the answer is absolutely yes. The convergence of communications and commerce, the increasing importance of communications in economic, social, and political life, and the more dynamic, interconnected nature of the digital economy means that the failure of interconnection imposes much greater harm than it has in the past. More so in the past, the economic harm is difficult to detect, impossible to predict, because in a decentralized world, we never know where innovation is going to come from or how important it's going to be. Centralized entities have a tremendous amount of vertical leverage, where discrimination can be subtle and extremely harmful. And so with a small number of integrated network infrastructure facilities, we need non-discrimination and the broader principles more than ever. At the same time, I have long said we must recognize that the form of regulation must fit the mode of production. Ponderously slow, common carriage may have been well suited for railroad tracks and copper wires and electric grids, which were homogeneous products that almost never changed. It was perfect for that stuff. It is useless in a dynamic digital economy. We need a new form of regulation to ensure that our basic values are accomplished. Fortunately, we already have two excellent examples of a remarkable new approach: the Internet protocols and the development of Wi-Fi. Both of these communication systems are based on brutally simple obligations of interconnection that open the communication space to all on a non-discriminatory basis in a way that had never existed before. This is a new approach to access. Both were supported by voluntary standards and managed by multi-stakeholder processes that promote interoperability. And both were created by regulatory actions of the government. The FCC, in its infinite wisdom, gave me Carter phone and the computer inquiries and the 802.11 standard. On its own motion, the FCC created those conditions which opened up these spaces. The private sector rushed in with voluntary standards to promote the freedom of access that the FCC had offered them. We have made a huge mistake denying the important role of government in the creation of this industrial revolution. And we face it when we go abroad, because we have spent so long saying there was no regulation that the rest of the world, which knows there was and knows we need it, do not like to listen to us. So Carter phone and the computer inquiries ensured non-discriminatory access to the network and essentially, especially, extended freedom to connect devices at the edge. Along came the digital revolution, which created immense computing power at the edge. Combined with the freedom to act, we had a digital revolution. Unlicensed spectrum was the most radical deregulatory act we had in the last quarter century. It gave universal unlicensed access to a key input for communications. To its credit, the sector immediately adopted a voluntary open standard managed by a multi-stakeholder group. That decision to deliberate a sliver of spectrum has created the core of the broadband age. More bits move through unlicensed spectrum than any other medium in our age. And if we make the right choices going ahead, that will continue to be the case. Ironically, the incumbent industries had an opportunity after the declaration of the 4 internet freedoms, which are closely related to this conference, to follow the model of the IP community, of the Wi-Fi community, after the broadband wireline order, after the cable modem order, and embrace a voluntary approach to an open standard to organize this space. And of course, they failed to do so miserably. They sued, they complained, they objected, they protested. And so the truth is that the open standard is the meat and potatoes of entrepreneurs and innovators, and anathema to incumbent network operators. So the problem is, going forward, we face a significant dilemma if we believe that we must expand the space between the market and the state. Let's be clear. What the FCC did in those Carter phone computer inquiries in 802.11 is they wrote a rule which basically said, here's a space where we won't regulate on a day-to-day basis. They said, here's the rules of engagement. They said, we will control the worst instincts of the phone companies in that space. And so you had a space between the market and the state in which entrepreneurship was unleashed. It's a grave mistake to think that the incumbents will ever agree to that kind of space. That is why I reject the concept of a social contract. We don't need a new social contract. We never had an old social contract. The obligations of public service were imposed on the network operators over their objection. They resisted, they violated, and that's why we kept having to sue them in antitrust court. They never embraced that. We need to impose exactly the kind of order that the FCC was able to create. Now, the dilemma is that I don't want the government regulating this space. It'll be too slow, and there is a tendency for it to emphasize control over freedom. I can't let the corporations run wild because their private interests are not synonymous with the public interest. The dilemma is that the one institution that's big enough to prevent the corporations from running wild is the state. And so now I have to find a way to use the state to expand the space between the market and the state. And I call it participatory governance. Oh, there's a dot. I call it participatory governance. It's very complex. It's got all these arrows into it. But it's based upon two observations. One, that command and control won't work. And two, the static basis of representative democracy, and you heard that also doesn't work. The representative democracy of the 20th century, we assumed a homogeneous public that would go to the polls every 4 years or every 2 years and stay home the rest of the time. That's not what our society is anymore. We are an ensemble of publics in which people can and want to be engaged on a continuous basis. And so it's not only economic regulation that needs a transfusion, an infusion, it's also political participation. Our polity needs that transfusion, and this is my suggestion. So I have no illusions that this is going to be easy. getting policymakers and their constituencies on the left and the right, and believe me, I get more crap from the left than the right. Getting policymakers on the left and the right to accept the limitations of both the market and the state is not an easy task, especially in the current political climate. It is even more challenging to get them to accept the idea that we can use the state to create this space between the market and the state. Yet that novel idea, in my opinion, is exactly what the success of the youth and the adolescence of the internet was, and that is the only way we will preserve it as it confronts its maturation challenges of the third industrial revolution. Thank you.
And Mark, I will assure you I'll do my best to give you some guff from the right. We're going to go to the next presenter and have all three of them present, and then we'll go to the discussants and talk about all three presentations and all three. The next from the government and the FCC, no less, is Zac Katz. Zac.
Thank you. So great talk, Mark. One of the things we may be able to come back to a little later on the panel is opportunities for the next generation of unlicensed spectrum policy, building on the runaway success of Wi-Fi. FCC is hard at work taking white spaces, which many of you are familiar with, to the next level, and trying to open up new spaces for innovations we can't yet predict. I thought I'd talk just for about 5 minutes about the FCC's role in a time of technology transitions, which this clearly is, and then about a discrete issue related to interconnection around voice or VoIP interconnection that the FCC has been grappling with, and I think will be grappling with for some time to come, and that I hope will lead into Jim's remarks. So clearly one of the defining characteristics of the age we're in from a communications policy perspective is the tremendous changes we're seeing in terms of technology transitions, and there's a few of them in particular that the FCC has been focused on. We established late last year Technology Transitions Task Force that I want to talk for a couple minutes about. This is kind of an interdisciplinary group at the FCC that's focused on the evolution in network protocols, particularly as we see networks transition on the voice side from TDM to IP, as we see networks transition from copper to fiber, and as we see networks transition from wireline to wireless. We're increasingly grappling with policy challenges, legacy regulations that may not make sense in these evolving times or may actually be slowing down these transitions. But also the ongoing challenges of protecting competition, consumers, a couple other core values I'll talk about, which Congress has directed us to protect, as Mark said, independent of the underlying technology that networks are using. Over the past 4 years, we've been focused on these transitions. It's not a new thing. The National Broadband Plan that we came out with in 2010, one way to look at it, I think, is as a technology transitions manual for government. A bunch of recommendations for the FCC, also suggestions for other actors to ensure that our policies keep pace with changing networks and continue to serve these values. There's been a lot of discussion in the proceeding that we kicked off as we sought comment on this Technology Transitions Task Force about whether there's some tension between enabling or accelerating the transition to IP networks and protecting competition, consumers, and the other values that Congress has told us to protect. And I think from our perspective, quite the opposite. The two are not competing values to be balanced, but they are core elements that need to be worked through together. So a word about the principles that are guiding us in this work. The first, particularly on the kind of voice transition side, is competition. When we think about the promise of the 96 Act and a bunch of policies that have been implemented in furtherance of that act, interconnection rules, roaming between mobile carriers, allowing consumers to take their phone numbers with them when they switch providers, preserving internet openness. These are, in a lot of ways, competition-enabling policies. And while more competition may be needed, I think there's been some very significant progress along these fronts. You take those policies, you take technological innovation, you take massive private investment, and we've seen an explosion in choices for consumers and innovators in the communications landscape. At the same time, these transitions raise important questions from a competition policy perspective. One of them that we may talk about later, as carriers transition to all IP systems away from TDM networks, are market forces alone sufficient to enable competitors to interconnect reasonably, efficiently, so that consumers and business customers have meaningful competitive choices? More generally, some have suggested that as we move to IP, we are, by definition or necessarily, moving into some utopian competitive environment, and that IP is necessarily synonymous with competition. We know that's not true. Technology transitions are certainly introducing innovative services, changing the competitive landscape, but competitive challenges remain. Millions of consumers today have no options for high-capacity, high-speed broadband. Millions more have only one. So we have to be nuanced, I think, in analyzing competition and ensuring that the many policies that we've inherited over the last few decades are moderated, are modified, are supplemented, or removed, rather than wholesale taken away. Second core principle that is guiding our work: universal service and consumer protection. Jonathan Salad showed that wonderful ad from AT&T, universal service, in the early 1900s, and through a combination of public and private sector activities, including the massive implicit subsidies of our inter-carrier compensation scheme, we succeeded in large part to getting telephone service to all Americans. We haven't yet succeeded in getting broadband to all Americans, and that's a kind of core challenge that we're working through. The third critical principle guiding our work is public safety. So technology transitions are having a couple kinds of impacts on public safety. New technologies, 4G LTE, the emergence of next generation 911, including things like text to 911, are providing great opportunities. FirstNet is a core part of that, to substantially strengthen public safety in this country, to harness the power of communications networks to make us all safer. At the same time, as we move from copper networks, many of which were self-powered, to fiber and wireless networks, which require an external power source, the electric grid, we're seeing, as we did with the derecho in the mid-Atlantic last summer and then with Superstorm Sandy, some real vulnerabilities with the resiliency and reliability of our networks that raise public safety challenges that we've got to grapple with as we move forward. So last thought, I guess, on the transitions task force, and then I'll move on to the interconnection topic that we've been asked to address. I think as we move forward here in updating and refining these policies, engagement from the wide variety of stakeholders, many of whom are represented in this room, is going to be critical at the FCC. And so I'd like to encourage folks to participate. We're going to be doing workshops. We have open dockets where people can file comments. We'll meet here in DC, anywhere you like, to make sure that we're getting the best ideas on this transition. A couple minutes on interconnection policy for the internet age. The focus I'll take here is on voice interconnection, and in particular, as we've seen networks move from TDM to IP, we've seen concerns both about regulatory obstacles and market power obstacles to the transition to IP interconnection in the voice space. We recognize that network owners may not always have sufficient incentives to interconnect reasonably in IP. And those challenges in the TDM world led Congress in Section 251 and 252 of the 96 Act to impose certain obligations that the FCC has been tasked with carrying out. We've taken a number of actions in this space over the last few years, but perhaps the most significant is the order we adopted at the end of 2011, reforming our universal service system, but also overhauling our inter-carrier compensation system. For For those who are not familiar with it, inter-carrier compensation is a decades-old system of implicit subsidies, a Byzantine regime that regulates the payments that phone networks provide each other for exchanging voice traffic. And among other things, it helped ensure that consumers in rural areas could get lower cost service than they otherwise would by consumers around the country, including in urban areas, paying implicitly these higher fees to their carriers. Among the consequences of this regime, particularly as we moved increasingly to an IP world, were skewed, distorting incentives. So there were actually significant obstacles that these regulated payments created to carriers transitioning to IP and more efficient interconnection technologies. It also created things like traffic pumping, phantom traffic, which I guess they're as bad as they sound. I'll spare the details for now. Kind of inheriting the situation and recognizing that there could be some very substantial benefits to consumers and to competition from starting to dial down the system in an organized way. We moved in that order to essentially eliminate the inter-carrier compensation system and remove this kind of multi-billion-dollar incentive to IP interconnection. It's a gradual process. We laid out a several-year roadmap. In the same order we did that, we did something I think equally important, which was the Commission said that we expect carriers to negotiate in good faith for IP to IP interconnection for voice traffic. As we dialed down the legacy TDM regime, it was critical to make clear that there were expectations that Congress has had arguably since 1934 that carriers will interconnect in the technology of the day, in this case, IP. And so where we find ourselves now, roughly a year in, is eager for evidence that the transition to IP is including interconnection agreements between carriers in IP, to the extent that those are the most efficient ways for carriers to interconnect. And to the extent evidence doesn't appear, I think there would be some concern at the Commission. So I'll stop there, but happy to revisit.
Jim?
Okay, let me start by thanking Phil and his team for this invitation. I'll note also thanks to the panel who are going to contribute as well. And I'll note that at the very first one of these, what was that, 11 years ago, Phil? 13 years ago? Thanks. I was on a panel with Mark, so thanks to him for, in addition to my mother being a regular reader of my work. Many of you in the room have been interlocutors for that entire period, and I appreciate that. My reaction to the interconnection policy debate has changed a lot since 2002 in the article that Mark wrote. Not that my conclusions have changed so radically, but I think the context has changed something, more than something, quite significantly. I'm a little bit put in mind of a cage match between Martha Stewart and Bobby McFerrin. On the one hand, one can't avoid the conclusion that interconnection in the internet space is a good thing. I don't think there's any dispute about that. But on the other hand, one of the things that the context of the last 12 years, or since the 2002 article has come out, is very much a don't worry, be happy attitude about it. And so what I tried to do in this paper a little bit, as long as we're reaching far afield for cliches, is to focus a little bit on God in the details, or the devil, if you prefer, or as my daughter would say, meh. I'm trying to do two things in this paper. The first is to reflect on some of the changes since 2002, where I called for a fairly broad interconnection requirement. And the second is to and I think the more important part of this piece is to try to operationalize what an interconnection regime might look like now if instead of writing law review articles or meta theory, we were actually going to try to write some rules. So let me say a few words about 2002. In 2002, when calling for very broad interconnection requirements, the debate at the time and what I was principally reacting to was a very strong argument for unbundling and wholesaling regulation in the internet space, what went under the title of cable open access at the time. And the point that I was trying to make then was that interconnection policy could largely maintain the fundamental openness of the network that we were concerned about without aggressive and necessarily price regulatory policies such as unbundling and wholesaling. Viewed from this perspective, I think I probably went a little overboard in 2002. I even called for an interconnection requirement for names and presence databases. All I can say in that regard, other than I'm happy to recant, is that I wasn't the only one who got that wrong at that particular time. But thankfully, I didn't lose any money on the deal. So let me spend the rest of my time on the second, trying to operationalize the interconnection requirement, because I don't want to recant what I think was the fundamental argument at the time, which is there is necessarily a role, and appropriately so, for an interconnection regulation regime. I've tried to break this down, responding to Ray, who's also been a 13-year interlocutor here, into 4 sets of 3. 3 premises, 3 building blocks, 3 rules, and 3 problems with the rules that I haven't quite solved yet. What do I press? Okay, so here are my 3 premises. Interconnection denials are possible and they can be harmful, right? And in the 2002 piece, and Mark talked about this a little bit, there's economic pressure from network effects and a variety of other things that suggest that there can be situations in which strategic denial of interconnection makes a lot of sense for private actors. That's a bad thing when it happens in some regards. It can be foreclosure. It can be bad in non-economic terms. Certainly, I was heartbroken at the story in the Wall Street Journal that we've all read about kids doing their homework at the McDonald's, because watching my high schoolers and how they go to school, they cannot be denied internet access on a daily basis. But, and this is a bit of the change of the context since 2001 and 2002, denials have proved to be relatively rare. And more importantly, even rarer have been those denials that actually resulted in loss of service or connectivity to end users. Yes, there have been some denials that have happened that way, and that suggests we ought to be concerned about it. But some of the denials of interconnection have been denials of a particular kind of interconnection that private parties wanted without the denial of connectivity to end users. And I think that's a fundamentally important distinction to be made. Nevertheless, my third premise is other background rules that we might have to solve or to address interconnection in this space are going to be inadequate. I won't say much about why I think antitrust doesn't do the entire job. The short answer is Trinco. The longer answer is Trinco plus the institutions of antitrust aren't fast enough in resolving the question of whether a particular denial of interconnection is a foreclosure. But also the undue discrimination regime, I think, which is where Mark is pointed, isn't quite adequate for my purposes either. It's just too vague, it's just too broad, and I will say there has always been discrimination in network industries of this sort. Value pricing in the railroad space, universal service cross-subsidies in the Bell system space. There is discrimination in the current network space, and there probably ought to be some innovation that shows us a little bit more discrimination in the terms of development of business models where content providers and carriers, for example, work together to solve problems like bandwidth congestion problems through fancy pricing protocols. I think there ought to be some more innovation. We're just inevitably going to see discrimination. I'll say a word about what we ought to do about that, a slide or two in. Okay. 3 building blocks. 3 building blocks for my proposal are, first, that interconnection is not unbundling and wholesaling. I think that one's fairly self-evident. It's different from what we were trying to do in the 1996 Act with respect to the local networks and what the cable open access debate in the late 90s and early 2000s thought we ought to do with respect to cable modems. It doesn't require fights over Telerik and ECPR and things like that to determine pricing rules on a grand basis. I'm not saying we can get away from pricing disputes if we have interconnection policy. We can't. And that's the second building block, which is there are a few papers out there that say we can talk about interconnection without talking about discrimination. And that just doesn't make sense to me. We can identify a class of disputes that are more about interconnection, that is, whether the traffic actually gets through or not, and a class of disputes that are really more about discrimination, that is, the terms under which the interconnection is going to be made. But I don't think we can talk about interconnection as if it lives in a bubble apart from the question of discrimination. As I say in my paper, being in the middle is a terrible place for an academic to be, but there you go. And therefore, the third premise is that one can define a different rule for interconnection and identify what we mean by interconnection, and a different kind of operational rule for discrimination. There's a gaming problem. I'll highlight the gaming problem on the last slide. But while there is a gaming problem, almost all legal rules come with a gaming problem. Well, enough of that. So here are my 3 rules. The first rule says internet carriers must interconnect directly or indirectly. It's not unlike the language you might find in Section 251 with respect to telecommunications. Carriers interconnecting. What are internet carriers? They're companies that offer internet access or transport to the public, and I use the quote marks there just to hearken to the notion that we've had in all of common carrier law, that the public doesn't mean the public, it means at least you're making a commercial offering to some segment of the public. The important qualification on this rule is indirect connection is a defense to any claim of denial of direct connection. And so the refusal, for example, not to get too real world about it, of an access provider to say to someone who wants a peering arrangement, no, that's not a denial of interconnection as long as the traffic routes around. And here I'm adverting to a really important paper, it's probably not gotten enough play, that Dave Clark and Bill Lair wrote for the TPRC, not this past year, but the year before, coming from the premise that transit markets are robust. And they say, and I think they make a very good argument here, that as long as transit markets are relatively robust, they provide a very important constraint to any bargaining breakdowns that may happen between carriers that want to peer, CDN networks that want to have preferential access to access providers, et cetera. When those negotiations break down and result in what might be called a denial of interconnection, it's not the kind of denial of interconnection which I adverted to earlier, which cuts off users' access to content and applications and services on the internet, because the robust transit market still provides an indirect interconnection, right? That's the connection that I'm trying to draw there. The second rule is that a termination of interconnection that will result in loss of service to end users must be noticed. That is to say, if I'm in a peering relationship and I'm going to stop it and I know that that's going to result to your customers losing access to a certain set of people, there's got to be a timing rule that says, that allows the access provider or whomever's on the other side of the negotiation to take advantage of this robust transit market to make other arrangements. And then the third rule that I have is that complaints about terms of interconnection are non-discrimination claims. And here's the point at which Mark and I begin to diverge, that intervention in this space, that is intervention by the government, the FCC, requires a finding of foreclosure. And so instead of importing the notion that a discriminatory kind of interconnection is highly likely to be anti-competitive or foreclosure, I put that in the prima facie case for the application of this rule. Okay. Let me conclude by identifying 3 problems that, that either will exist or that I'm still working on. The first, of course, is the possible gaming by exclusive deals. And here I have in mind, if I'm a CDN who wants to take advantage of the notion that the failure to grant a connection results in the loss of access to traffic, and I'm doing it against Speta's background rule, or rather Clark and Lair's background about the robust transit market, if I can sign up content providers to exclusive distribution deals on my system, then I can present myself in that position. I don't know exactly what to do with it other than to say, we have to resolve whether this is certainly a gaming situation or not. But I will say, I think the possibility for that sort of gaming is relatively low because in general, the content providers won't have incentives to enter into those sorts of relationships. The second problem that I haven't decided what to do about, or that is maybe just a problem, is what to do about proprietary CDNs. It's not that different from what I've just identified. Here, all I can say is there haven't been enough problems out there in the market for me to identify what we should do about them. The third is, and this is less a problem than just a clarification, what do I mean when I say the primary case has to be foreclosure? Why aren't we just talking about antitrust? And here I think that what I want to say is I'm proposing an antitrust standard in an administrative setting. A number of us have talked about things like that over time, ranging from the DACA project to a variety of other proposals. I want some space, I don't know how much space, but some space for an agency to make a predictive judgment that there will be foreclosure, as opposed to the kinds of evidentiary standards that we usually think about in a classic antitrust proceeding. Boy, it's quiet. That was the last slide, by the way.
So let me start by asking Len to react to the presentations generally. You heard from, I'll call it Mark, a stronger interconnection concern than I think you did from Zac and Jim. But from all three, you did hear that we need some degree of vigilance. Certainly your company has been thinking about this a lot. How would you react to what you've heard, and maybe start there?
Okay, thanks, Ray. And let me also thank Phil and Silicon Flatirons. This is a terrific event. Let me also thank the presentations. And I think it's really notable, and I appreciate that I think all three have acknowledged, look, the old common carrier legacy regulations don't apply here, and also acknowledged technology is changing rapidly. And I appreciate that recognition. But why might I still have a concern, and I do have a concern, about any sort of regulatory intervention or mandate? And what I suggest is we ask ourselves two questions. First, is there a problem? What is the problem we're trying to solve? And I think as Jim described over the last couple of decades of experience, when it comes to IP interconnection, we really don't see a serious problem. The industry has flourished. Interconnection has grown unimaginably. Thousands of networks across the world have interconnected. That's been on commercial terms and sometimes no more than a handshake among carriers. And that's happened because it's good for the industry as well. So I do take some issue with Mark that the market incentives for the ISPs don't align with the public interest. In fact, while this is not an ISP or an IP example, let me just mention, if you go back about 10 years, 11 years to when wireless texting was first introduced, when it was first invented, texting, SMS, was an intra-company experience. If you were an AT&T customer, you could text to another AT&T customer, but you couldn't reach anyone else, and that applied to every single wireless company. But without the benefit of regulation, without the guidance or mandates of the government, the industry got together and developed the operational, the technical, the economic arrangements to allow interconnection of texting. And what was the result? Well, in 2001, texting was a $26 million business industry-wide. By 2008, it was a $5 billion business. So that underscores interconnection is important, but it also underscores that there are real compelling incentives for carriers to interconnect. And I do think IP does matter, because IP technology, with this amazing ability for packets to find their way to their end destination across a web of indirectly connected networks, matters, and it does impose a real constraint. So that said, it brings me to my second question to consider. Well, if you're going to interconnect anyway, what's wrong with a simple duty of interconnection, or one of the flavors we saw here? And my concern there is no simple duty of interconnection. You would create a sandbox in Washington, and most of the people in this room will come and play. I mean, all the special interests will be there. And then you'll be challenged on pricing, because you're pricing too high, so you're avoiding your duty to interconnect, or your quality is too low, you're avoiding your duty to interconnect. And then we're talking a very significant expansion, because what's a network today? And are we really talking about just connecting the wires? When AT&T is an all-IP network and every voice connection is VoIP, is it going to be adequate that we connect the wires but don't require interoperability for VoIP, the 100, 150, maybe 200 million connections? Well, no. If you believe in a duty to interconnect, you're going to want to see it extend to the incumbent's VoIP. Well, how do you then, with any principle, with any absence of arbitrariness, Leave the largest telephone company in the world out, Skype, right? You don't. So we're really talking about a duty to interconnect that extends to pricing, extends to quality, and now expands regulation beyond the telcos into the entire over-the-top space, and it doesn't stop. I mean, Skype, what is Skype? What is Xbox? Is it a hybrid service? Do you extend it there? And then we're even concerned, what if a content company, we have a recent example of this, is the entity that says, I don't want to interconnect. Do you manage that? What if it's Google, which is a search engine, and they say, you know what, I realized I can make a buck here by telling ISPs, if you want your customers to reach me, you have to pay me. Now, I'm not saying any of that is good or bad. What I'm saying is, do we want the government in the middle of that? As we heard earlier today, the U.S. government, the administration, spent a lot of time and resource telling the rest of the world, you shall not regulate interconnection, you shall not regulate the internet. And there was a reason for that, because we're concerned about the implications of it. So what I'm really saying is, given our experience with IP interconnection, given some of the risks and the undefined nature of regulation, it often being a one-way ratchet, I'd argue a counsel's in favor of some humility, some moderation. Let's see if the market develops. I'm not naive enough to think there isn't going to be oversight, that all the people in this room aren't going to be watching. But what I say is, let's try it first without the regulatory sandbox.
Lynn, Len just expressed a couple concerns. One, the simple Speta interconnection rule just turned into the rule that ate and regulated the entire internet. By contrast, we have Mark saying very firmly that private operators' incentives to engage in harmful discrimination are persistently strong, even in the digital IP era. Where do you come down on that question, and is there a means to craft a simple delimited rule, or do we end up with a rule that ate internet regulation?
So let me talk about this issue of incentives to begin with. I find it fascinating that we have people talking from the sort of legacy PSTN framework and mindset, and not having paid attention to what's gone on the internet, and that suddenly it's been discovered. So for decades, you've had the internet becoming more and more interconnected. First, it was just the tier ones all by themselves creating interconnection relationships, and then suddenly you start having the tier twos, all these new entities kind of move in and start just absolutely burgeoning interconnectivity all over the place, interconnected with each other, interconnecting with some of the tier ones, interconnecting with transit providers, interconnecting with CDNs, which only come about because we're willing to interconnect directly with them. You actually only have internet video really start burgeoning because all of this direct interconnection at all these levels starts getting the price of transit to plummet, which makes all of this affordable. So all of this is happening, contrary to what Mark says, with all due respect, with no government oversight, but actually because there is a reason and an incentive for all these companies to interconnect. Their businesses rely on this total interconnectivity. And what's happening now is that suddenly it's like, oh, people have woken up and said, oh my God, there's a terminating monopoly. You could block interconnection here. Well, meanwhile, we've all been interconnecting with these terminating monopolies and not blocking anybody for years. Now, in 2002, you have Sprint and Cogent. There wasn't quite the degree of transit or other routes available then. You also have in that scenario, by the way, the fact that there's a tier one provider there who doesn't want to not be a tier one provider, so doesn't want to pay for transit. If Cogent had been willing to pay for transit or pay for interconnection, there would have been, I mean, I think your example is a null set, frankly, because today the FCC just a little over a year ago says there's 38 transit providers, there's ubiquitous connectivity, and this is in the global crossing level 3 order if people want to look this up, and that companies are 88% of companies are multi-homed, so they can pretty much get to where they need to get, regardless of the little dispute that their particular provider is having, and beyond that they can switch transit providers with just incredibly easily. Beyond this, half of the folks out there, the CDNs, the content providers, can actually dynamically route their traffic, so they can dynamically switch transit providers or switch routes. So it's suddenly everyone's sort of woken up to the fact that there's this threat there that hasn't actually come to pass. And what everyone's not paying attention to is while you're looking at what the internet used to look like and suddenly worrying that there's some block there, which seems not to be exercised, what you're really seeing is a shift of traffic to these few major content providers and CDNs that control an overwhelming amount of the traffic on the internet. And the real shift today is not that there are some terminating access monopolies that have about 15 routes into their networks that they don't control through transit providers. It's that these other providers of content, CDNs and the like, have an enormous amount of market power on the internet. So Jim, I think it's really ironic that now, in this era, you're saying perhaps I don't need to worry about those entities and make them interconnect, when, as Len tells us, they're the folks who can actually decide not to connect, not to send content, to withhold their services, and that's not a problem for the internet experience. There's no way to get that. There's no transit route that gets you that stuff if they don't want to send it to you. On the ISP side, we can't block. That's again, it's a null set problem because the net neutrality rules say we're not going to be able to block. So as long as you have a transit route, and there are 38, and most of us are interconnected with all or most of those folks somehow or another, we can't block. So all you're talking about is the terms of a direct connection and what it should be like. I think we're talking about a problem that doesn't exist, and we're making rules now for a problem that didn't exist yesterday, but certainly isn't going to exist tomorrow.
So if I set Zac aside for a second as a neutral.
You did invoke the network neutrality rules as a key ingredient in the space you described.
Yeah,
Okay.
I heard
Okay.
that. I heard that.
This is a rule. Okay. This is a government rule. That's
All
it.
right.
If
But
I
the
could-
one side,
if I
one
could
side,
Leslie.
I wish I could. I wish
All
I
right.
could.
So I'm throwing you the softball, Leslie.
A softball. You have no idea where I am on this right
Well,
now.
no, I was
have
trying to-
no idea where I am.
So
on
here's
this.
the question. I want you to break the tie. I've had,
no, I can't
setting
break
Zac aside as, Zac and I, of course, are sedulous neutrals,
Oh, yeah.
looking at the public interest from afar.
Yes, right.
We've heard
Too far, not too far.
from two folks from industry who say there's no problem, and by the way, the regulation is going to cause more trouble than it's worth. We've heard from an academic and a peri-academic here that we do need rules and we need to worry about this. So how would you break the tie here, Leslie, on the
okay.
panel?
First, I just wanted to say to Jim that if he thinks it's a problem being an academic in the middle of the road, try being an activist organization that's trying to find a place in the middle. I can't break your tie, and I can't break your tie because I hold two things that I believe to be absolutely true. One is that I agree with Mark on history, and so I do believe that there are forces in play right now, just beginning, whether it's the asymmetry of the traffic, there's a number of things that are going to create more conflict. And so, there's a part of me that says the day will come, not today, the day will come when we're going to have to come up with something lightweight. And no offense, I shake when I think that it's the FCC. So, well, because of what I hold equally deeply on the other side. We talked about this morning coming from alternative universes. I think this was Phil's idea of torturing me because I come from the internet. I haven't spent my life as a telecom lawyer. I also play one on TV, and the sense of unleashing rules, and I thought Len was fairly persuasive on this, at least given how little I know at this point, that would quickly morph into the application layer is something that really, really worries me, and because I've spent my career since there was an internet saying keep your hands off the internet. And so I hold these two things really, really strongly. And so I can't give you a rule right now. What I'm really aware of, being on the outside, where the deals aren't struck and whatever private little assurances go into the FCC, so they have some data, that if you're sitting in this multi-stakeholder world that Mark is just sure is going to work so well, that there's a set of facts about deals, about what's happening in the market, about what's happening in the negotiations, and there's no transparency. And I don't mean transparency of putting it in the Washington Post. I have no facts with which to break my tie right now. I hold both of those things. I think they're true based on a variety of things. And I don't know how we get to the point that everybody, I mean, I think everybody who's got something to say, I've been forced to have something to say, honestly. I wasn't really ready to. Knows a little bit about what's really going on. And the carriers probably know a lot about what's going on. And some of the big CDNs probably know a lot. And my guess is really out there in the backbone, nothing's going on. It's just how we want it to work. But until there's somewhat more of a common set of facts of either problems that are happening or trends that make it really clear that we're headed in a particular place, I'm stuck holding two truths. One that I worry about ultimately, the battle of the giants doesn't bother me. At the end of the day, it's the internet users, and I'm just going to try to stop calling people consumers here. The whole conference we called internet users consumers. They're part of this entire ecosystem, and I think we have to switch that around a bit. Have done well because of interconnection requirements. And what we've got today is because of interconnection all the way back. I think Mark's right. But I can't reconcile that today with a rule. Now, I think Jim's pretty darn close on a rule if we ever got there. But I'm just not comfortable yet saying, we should do this now. I think we have to start discussing it. And I'm a little bit worried about how far his rule goes toward the antitrust side, and therefore maybe you can't actually ever win. But I think it's a very thoughtful first effort if we get to the place where that's what we need.
Well, I'm going to ask a question to both Jim and Mark, slightly different, which is, Jim, I wanted to press your rule. Why not go back to the pure antitrust side rule, where you've got to show actual harm? Because part of what we're hearing and we've heard is there are no instances of harm, and maybe an antitrust rule in a different administrative context may solve your antitrust too slow problem. And Mark, I want to, with trepidation, give you a chance to speak. Not because I don't love to hear you speak, but well, let's just leave it at that. But you also, you pride yourself on being a practical progressive who understands the limits of institutions as well. And what you talk about in your paper is not a traditional, straightforward, here's a rule, let's go give it to an agency to enforce. Quite the contrary. Yeah. So why don't the both of you expand on that, and then maybe we'll go back to Zac.
The distance between Jim and I is, in one sense, very small. I have no problem discrimination. I call it differentiation, since we've mucked up the word discrimination, and everybody hears the wrong thing. So he says, do discrimination is good. It's differentiation. So let's go. So the question then becomes, we have two differences. One, does the traffic continue to flow during the dispute? I want the traffic to flow during the dispute. He wants it to stop, I think. So second of all, who bears the burden? And I have a very different view of the burden. That is, I want the burden. He wants the burden to be on the victim of differentiation, and the burden must be to show harm. I want the burden to be on the network operator, remember, traffic flowing, to show that the discrimination is in the public interest. Because of my argument about the importance of interconnectivity.
Well, that's quite a significant burden.
But on the one hand, it's a difference. That's not true. But on the other hand, it's very, very precise. But the interesting thing is I'm sitting on this panel, and I think there are four. I heard if Lynn really meant the network neutrality order plays an important part here. I know AT&T supported the network neutrality order. Obviously, Zac did. I supported it vigorously and took an immense amount of crap for that. 5? Well, I wasn't sure what Jim thought and what you thought. But so the fascinating thing is that the commission produced an order that would appear to have a lot of support, except from everybody else. And we'll see the et cetera. But to me, it's really interesting that network neutrality order, and it's unclear.
I'll reframe. I mean, we did not oppose it when in the final version. We didn't think it was necessary. We think the internet's open. But you're right, we did not appeal it. We did not oppose it. We think the FCC, after struggling with it, came out with a balanced statement, and that's what we've said publicly about it. But do you need it from the beginning? Now, you have an open internet. I am concerned about establishing new duties that, as I mentioned, are going to bleed into everything. You know, it's the Pac-Man of the 21st century.
And Mark,
but it envelops everything.
Right now you have a rule, and the rule may be fine, but I think you're now starting to see distortions from it because you've got relationships where only one side can actually walk away. Like Jim's worried about the walk-away rate. One side of this relationship can never walk away from keeping the doors open to those 38 transit routes. The other side of this relationship, all the content providers, the CDNs, the folks who aren't going to be covered by Jim's rule, they can walk away. They can withhold content. That's an inherently distorted set of relationships.
Well, but on the other hand, I certainly don't want to extend FCC regulation to the other side.
Neither do I. Let's just let 1,000 flowers bloom.
Well,
and take it all.
they can bloom in the right garden, and the network neutrality rule is the right fertile ground in which you plant this stuff,
Okay,
right?
so let me ask Speta about an antitrust rule, since you've been challenged that even your rule could be the interconnection rule that eats the internet.
Sure. Let me back into it just by saying one word, 2 words, half a dozen sentences about the net neutrality order. Those of you who've been my interlocutors for 13 years know that I don't think the FCC had or has the authority to do the net neutrality order. And we'll get an answer on that. And the answer can be bad, that it doesn't have the authority to do it in one version of the world, which upsets the world. And the only thing worse than that, in my view, is a confirmation that ancillary authority is so broad that it can do that. It doesn't address the sort of predictability concerns about what the regulator is supposed to do or what the regulator has the power to do in the future. But if you want to hear more about that from me, read the article I published for Phil 3 years ago on this topic. So I just don't think they have the authority to do it. We'll get an answer. Well, I thought we got an answer, but we'll get another answer. Sorry.
No offense taken.
I take Lynn's challenge quite seriously. I'm quite agnostic about how robust the market is and if the market is robust enough to say that we don't even need an interconnection rule, because I agree that an interconnection rule starts a ball in motion. Now, I've tried to describe certain kinds of disputes that I think are different from other kinds of disputes. And maybe this is ancient history, the cogent interconnection walkaways or whatever we want to point at as the kinds of interconnection denials that result in the loss of the kind of connectivity to users that we really care about. I want to be humble about being an academic who sits in Chicago, right? But I will say that there are plenty of people out there, ranging from carriers to the Dave Clarks of the world, who think that we need an interconnection policy. Now, Dave's first step in this paper that I've referred to a couple of times now is to say we need better information about what's going on out there, right? Some of the transparency stuff that Doug was talking about at the beginning of the day, although Dave's proposal reaches a lot deeper. And one of the things I was trying to do is to say, when we have a transparency rule, or when we have a rule such as the stuff Phil and Joe have been talking, and lots of people have been talking about in terms of co-regulation, et cetera, what we need, what there is inevitably at the end of the day is a substantive backdrop, right? There is inevitably at the end of the day a law that says these are the things about which transparency might make a difference, right? These are at the end of the day, we might be able to infer from a price index something about market power. These are at the end of the day the things that emerge out of a co-regulatory process that the FCC is going to bring a hammer down on you if you don't do what the co-regulatory process suggests that you do. I'm deeply agnostic.
You might be right.
I'll
Zac?
respond just for a minute. So, two types of interconnection that we've been talking about. One on the IP side, internet traffic, and the other on the voice side, whether in TDM or IP. I think there's reasons to believe that still today in 2013, you need policies in place to ensure, at least on the voice side, that you're going to have reasonable, efficient interconnection that benefits consumers and competition. There was a tweet, I think, a few minutes ago just to this effect. It's not as if with a bunch of transit providers out there, no matter how many you had, you would find alternatives to incumbent LECs switching and transport facilities. And the ability of a new entrant or competitive entrant to offer voice service in a market today would be materially constrained in ways that I think would do tangible harm. On the IP side, I think Lynn is right to note that the Open Internet Order establishes kind of a baseline rule of no blocking. Only one company has opposed that order. We very much hope that that order remains in place. And as long as it does, I think we're in a position of monitoring, of tracking, of evaluating discrete issues like the Global Crossing Level 3 transaction that the Commission approved with no conditions about a year ago. In a status quo that, at least at the moment, we're not proposing to promulgate any additional rules, specifically with respect to interconnection, to regulate.
So, Len and Lynn, let me ask you, Zac talked about maybe a method of soft regulation from the FCC I think called regulation by raised eyebrow, where you say there's a good faith obligation to engage, or in good faith negotiation for IP to IP interconnection. Is that I don't want to call it a rule, but is that an impulse that leaves you just as cold, or is that kind of soft government concern for something we think is important, but we don't have the means to formulate a executable rule for, still a problem?
Just quickly, to be clear, that was focused really on IP to IP interconnection for voice traffic.
Voice traffic,
so
okay.
when you have a Skype, they use a LEC today to interconnect their voice traffic with traditional telephone numbers, and that's the environment in which that was being discussed.
Okay, no, thank you for the clarification.
Look, we all want to get to an IP to IP. I mean, AT&T filed with the Commission a petition to begin a trial in 2 wire centers, fairly modest effort to try to say, can we convert these old facilities to IP? What does an all-IP environment look like? So clearly we want to get to IP interconnection and termination of VoIP, as well as every other piece of data coming over the internet. What I go back to and I worry about is this effect, this Pac-Man effect of regulation. What I'd suggest is the FCC's focus, given the market, if the market continues to work well on the IP to IP interconnection, should be focused on consumers or in Leslie's terms, internet users, right? Get out of the business of refereeing among companies, because when you do that, inevitably, you bring a lot of money, a lot of interest, a lot of resource into a debate in Washington that's not focused on competing in the marketplace, but focused on shaping the rules for the marketplace. And that's a significant concern going forward.
Well, but don't misunderstand me. What I'm saying is the FCC's role here is to worry about those things, not just to worry about them for, there's plenty of giant-to-giant business fights, and I don't sort of think per se we have any interest in that. It's when there's a reasonable belief that this is affecting internet users, or to take the predictive model that this kind of behavior over time, then I think we've got a concern in the marketplace. Internet users, innovators, I think they have the same interest here, and I think more or less the same practices are going to have the same impact, whether you're the over-the-top provider or the user. But I don't want to sort of start from an assumption. I don't want to, I'm not looking I don't really want to see proceedings at the FCC about pricing disputes. Right. I mean, so it leaves me, and I appreciate Mark's idea of multi-stakeholder. My experience with multi-stakeholder, frankly, is that having the interim effect of knowing that a regulator can do something makes people more willing to not just come to the table in these kinds of things, but perhaps reveal facts that make it useful for everybody else who's participating. So this is how I wind up in a little bit of a hamster wheel, because if I'm not that anxious to regulate right now, but I like multi-stakeholder, but I'm not sure it has, that we're sitting in a room around something where I'm not sure that there's any impetus for people to start sharing stuff.
Well, the point is to fill the space. That's the point about the voluntary multi-stakeholder processes that have run the Internet protocol for 30 years successfully, have run 802.11 protocols for 25 years successfully. And there's always this question, and whether what the four freedoms were, there was a moment there that could have been seized. The network neutrality order is a moment that can be seized, and the point is that, for the question here, it's interesting. So I'm trained as a political sociologist. I might have said this last year. And the core concept of political sociology is legitimacy. And that is what everyone's talking about here. What is the legitimate governance regime? And we're looking for governance without government. And it's a really important concept for the internet space. So Leslie beats her head against the multi-stakeholder processes with lots of people who may not really have an interest in behaving, and the key people who won't come into the room. So she says, I got to have a reason to get AT&T and CFA and CWA into the same room who have an interest in making the space work.
That's right.
We have an interest in making this space work. And I think the network neutrality is a space like that, where you can develop those things, but it's not easy. It's hard.
It's hard.
BitTag's
hard.
But the FCC is the worst place to have these conversations. And I've said that to every... The best, someplace else to have the conversation, so that when somebody tries to do something silly, if the consensus says that's dumb, it doesn't. The dispute never gets to the FCC, because the collaborative will has suggested that here's behaviors that don't make any sense.
But Mark, I mean, on the legitimacy point and multi-stakeholder, I mean, if we were to get to a world where we knew we had to have an interconnection when bad things were happening, then I would look for some combination of your proposal and Jim's, because at that point, co-regulation by itself, I think, would not be legitimate. I mean, if we were in a situation where people were, users were being disadvantaged, then I don't think that co-regulation has the legitimacy.
Can I make a
broadly
point?
At this point.
AT&T is not talking about a regulation-free zone.
No.
And we recognize that what we're saying is interconnection is the wrong place to be having the discussion about regulation. Zac, you mentioned the public safety area, accessibility, universal service. We recognize that there's a role there, and it may be that we should be looking for creative ways to close some of that gap, the text to 911 issue, where the four large wireless carriers came together with a proposal in consultation with the FCC. But I'd like to see that broadened, right, to the broader ecosystem, because there's a lot of text providers, and they all aren't traditional CMRS providers. But there are these important policies that affect end users that we think is where the focus should be, and there may be creative ways, much in the multi-stakeholder approach I've described, to achieve those. But when you come to interconnection and you begin to talk about tinkering with the model that's worked, the technical and economic model that's worked to date, you run the very real risk of damaging or destroying an engine that's been so effective over the last 20 years and creating this internet miracle we all have a stake in.
Well, Lynn, will you have a problem with the good faith kind of exhortation from the regulator? And let me take it a step further, because Mark and Leslie have certainly taken it there, and this is Silicon Flatirons, and we love to talk about this, which is the institutional context into which any of these either rules or processes take place matters a lot. And there's a very big difference between having a rule that churns its way through the FCC process or an adjudication that makes its way through a more FTC-like process, and the multi-stakeholder or co-regulatory process where there is some intermediate group that can offer some sort of outcome, maybe not prescriptive, but advisory. So I've asked you like 4 questions in one.
I'll choose
So
one
answer
to
whatever
answer.
you want to answer.
So on the good faith exhortation, if I could quote Howard Chalansky from, I think, last year, I think beware of not so sweet nothings. Is that yours, Howard? Yeah. That was yours. I don't see how you meaningfully enforce good faith interconnection obligation without ultimately talking about price. Because again, if you look at the disputes, the only disputes that anyone can come up with, they're all about price. Someone wants something for free, someone doesn't want to have to pay someone else for transit. They're not about, I will not take your traffic. There's no disputes like that we're seeing on the internet backbone. I don't know of one, and even Jim's 2 examples, I think they end up being just the same example. They're both situations where there's an argument about price. So if you don't want to get into the guts of pricing interconnection on the internet, I don't know what you do. How do you unpack that good faith interconnection obligation? And again, just to go back to the horse I'm going to keep beating, I don't know how you have that obligation and you make it one-sided. If only one side has this good faith interconnection obligation and the other can always walk away, then it's you're really just saying to one side you have to do whatever is asked of you. And when you're talking about significant infrastructure investment and costs that can be stranded at a moment's notice when someone decides to go some other route, that's a really unfair regulatory construct to build. And I would just say, even taking that into the voice question, I think what we've said is just exercise some caution. You don't even know what kinds of interconnection arrangements make sense yet. So how are you going to assess whether someone is acting in bad faith or good faith until you know how this should work and what it should look like and what is a fair arrangement or what isn't? And what we've said is, let's see, why don't you let some of this develop a little bit, because we don't know how the interconnection for voice is going to work in the IP network. It could work just as well as the transport of internet traffic generally, or maybe it won't, and then maybe there is a role for the FCC, but I think it's premature to make that decision, because if you do, you're inherently getting into price regulation on day one.
Yeah, and I do want to drill down, because it's well taken, at least by me, Jim, that if you get yourself into the pricing business, which you inevitably have to, you are playing a loser's game in a really fraught area that is impossible to do right and damn easy to fall into error.
Well, I think that's right. And I think, at least my rule is designed to avoid almost all pricing disputes, except for those pricing disputes which would be cognizable under an antitrust standard. And unless we're going to say that a pricing dispute is never cognizable as a foreclosure dispute under antitrust, then, and I don't think we're going to say that, then we do have a little space in which we're going to fight about pricing disputes, right? I want to say 2 things about the one-sidedness. My definition, actually, of an internet carrier applies to a content distribution network.
Yeah, I was actually going to ask you.
It doesn't allow them to escape from the interconnection obligation, but the difficulty, I think, and this I tried to say this on the problem slide, is separating out what the scope of regulatory authority is, because I don't think we want a rule that demands interconnection from content providers. That is to say, if I'm the person who owns the copyright in the United States in, I don't know what I want to pick, the Olympics is a good example, right? And I want to provide that on the internet, but in a more cable television business model where I provide it to users through a back-end deal with the cable companies, right? Or ESPN3 or a few other examples out there. I'm the copyright holder in Bundesliga soccer games, right? And so I don't want an interconnection rule that applies to the content providers, but I'm having an interconnection rule that applies to the CDN because they're transport providers in the way that I've defined it. But, and this comes back to the pricing issue. I don't have a rule that says you get to go to the FCC and complain about your prices. I have a rule that says you get to go and complain that the terms of the interconnection are acting as foreclosure, right? And there are a whole bunch of intermediate steps that I do think institutions are important, whether they are co-regulatory institutions, whether they are baseball arbitration, which my colleague Shane Greenstein has talked about in the carriage space, and I take it from lunch, Mark's going to talk about in the standard essential patent space tomorrow. There are a whole bunch of institutions that can be used, but the only service of my interconnection rule is similar to Mark's, which is the traffic flows. But I'm trying to avoid I am trying, and maybe I'm failing. I am trying to avoid the pricing disputes. Absolutely.
So I have this other question, because I'm trying to think through how much of the net neutrality rule, the open internet rule, as we now call it, either already takes care of these questions or sort of poses sort of another tranche of arrangements. I mean, we have this giant thing called special services, right? Specialized services. And I'm having trouble understanding, so the CDN is going to somehow negotiate for this cable thing. Is that something that, I mean, we've just given people permission to do these special deals. Does that somehow...
I'm happy to talk about that one further.
How do you unpack these two pieces, which I am having a hard time doing?
Yeah. So I think when you look at the Open Internet Order, the rules themselves are less than a page. I know you're familiar with them, and it's basically three things, right?
But that's what I was
transparency, no blocking, no unreasonable discrimination, and then in the discussion of the order, it talks about the ongoing provision of services that broadband providers have been doing for years and are continuing to do. That are different from broadband service. So you've got your VoIP services, you've got IP video services, you may have other services that have special protections or prioritizations built in technically. And the discussion in the order is that as long as you don't see the capacity available for broadband, open internet services, constrained or failing to grow as one might see it grow, there wouldn't be cause for concern. To the extent you didn't see those things, it might be necessary to take a further look, but that's the kind of high level, let's get some principles out there, and then let's see, as the market develops, as business models develop, if another look has to be taken. But there's no imminent plans to do that.
I've been preaching on this for a little bit, which is the open internet order or net neutrality rules drives innovative business people to want to provide innovative products as specialized or managed services.
That's what
right?
I think.
Because the net neutrality rule, whether it'll develop that the open internet rule works this way, but a net neutrality rule creates a space in which certain business models are not possible, which are possible in a cableized or managed service or specialized service thing. That doesn't make any sense to me.
We don't. The point is that so brutally simple has this tendency to be remarkably efficient in this space, and so they wrote a rule, and I'm really pleased to discover that we've had it for 16 months or 18 months or whatever, and we haven't had a lot of screaming and shouting other than the court case, but in the real world. It's chugging along,
so I think
folks.
This bears noting, right? You've seen over the last really 3 years since it was proposed, tremendous innovation at the edge. I think hard to see widespread examples of interference with content or applications. You've seen tremendous investment in broadband networks, both wired and wireless. Hard to see that on the network side things are grinding to a halt. And so, the parade of horribles that some folks have discussed, it's not clear that that's manifested yet or that it's on the verge of manifesting.
There could also, though, be an argument that proves too much, couldn't it, Zach, which is that that was irrelevant to the development of the internet, and could we also say, and maybe Len already has, and Lynn as well, that an interconnection rule relating to IP is going to have no effect. Now,
and we haven't proposed one, actually.
Right, no, I know.
But it's true. I guess the point is simply from the parade of horribles on both sides, I think it's hard to see either of those having been borne out by the historical record. That's not to say things might not have gone well in the absence of an open internet rule.
But again, and I don't want to relitigate this debate, so I think it's a mistake and it's backward looking.
Definitely was not my question.
But the point is any ISP who doesn't realize that an open framework is good for it or determines that a closed framework is better for it is making a huge mistake. AT&T has established foundries, invited applications developers in. We're trying to open as many APIs as we can. We recognize the way you create value in the network is by creating value at the edge and having it interoperate very well with your network. So to some extent, your point, I agree that maybe it's irrelevant. Maybe we all were headed towards openness and want openness, and the fear goes back to that earlier point, maybe I'll state it differently, is impeding flexibility. Because we heard this morning, too, about the concerns about the enormous investments needed to put into these networks. No company invests more, no American company invests more than AT&T in infrastructure. And that is ongoing, and in November we just announced another massive investment plan for the next 3 years, both in wires and wireless, to enhance broadband. So the concern is, let's not get in the way, and I'm not saying, I'm not having the debate, I'm not saying the rules do this or not. Let's not get in the way of the ability to explore innovative commercial models as well as innovative new technologies and innovative new capabilities. And the concern I've got is anytime you have a rule, regardless of what the rule is, it becomes a hook that could invite controversy, slow down development, and impede innovation, not enhance it. Sorry.
No, I mean,
Well, but so you've got this. So the question is, it hasn't done any harm. Things have progressed really well, but now you've precipitated the question of interconnection and IP, and I'm told that.
Like you said, we precipitated it.
Well, you petitioned for the FCC to maybe do something about it, and you tell me that I should not write a rule there. Lynn says, don't write a rule there until we see what develops. Let's let the commercial. So my initial reaction to that is, well, okay, if you're waiting to let me see what develops, the last thing I want to do is give up my ability to regulate IP voice or voice, right? Because I know what I have there. I know it's worked for 90 years or whatever. And if your system blows up on me because it doesn't develop well, this may be the only legal hook I have in order to defend myself.
So does that extend to Skype? Does it extend to Vonage? Does it extend to all the other? I mean, Skype's got more customers for voice than anybody else in the world.
Yeah,
And they struggle with, because they misclassified high-speed data transmission, they struggle with dealing with that, okay? But again, it's just like your business models, could there be managed services we hate? Maybe, but there haven't been any. Right. And can you tell me that this is the managed service I would have done if you didn't have that stupid order? You haven't come up with any. And you've proposed a couple, and people have raised their hands a little bit. But if you look at, given the horribles that both sides predicted, our side if we didn't have Title II, and your side if we had anything, or Verizon if we had anything, the simple fact of the matter is the space works pretty darn well.
You just
oh, go ahead.
And so
you're going to
why
end
do
this
I?
with the space ends pretty darn well. You started it with, we need a rule.
I started. We need to expand that space. That's my proposition. But now if I'm told, well, wait, I'm not going to give up what I've got if I'm waiting to see what this new space is going to do. But my goal would be to expand this space, and the way you do it is to find a way to have sensible conversations about managed services before you throw them in the room and they explode on you, right? And that's kind of what happens in the Internet Protocol, where people put forward their ideas about how they want to develop the protocol, and the community looks at them, and that was one of the complaints about the Comcast BitTorrent, was they never brought it to us and talked to us about it. It turns out it was easy to fix.
I mean, if
The
you're talking,
technical fix
if
was
it's
simple.
norm setting, then I'm all for multi-stakeholder. If it's sort of final decisions about particular matters, then I start to get nervous. If I, just resolving the disputes between two parties without anybody really taking sort of public interest values in, and it's all about sort of resolving a business dispute, then I worry.
Jim?
I don't know. I was hearkening back to the mistake I made and others made about whether the NPD was going to be the, AOL's NPD was going to be the default addressing space of the internet that we were all envisioning at that particular point in time. And boy, there was a lot of obsession with it at the time. The reason I'm hearkening back to it is I'm struck by the question, what's this obsession with voice? And my reaction to it is twofold, which is, first of all, I have 2 high schoolers. Voice? Are you kidding me? And the second of which is, yeah, okay, sometimes they do voice with each other, and they do voice in a hangout on Google, and they do voice on Skype, and they do voice on... I've seen my son, for God's sakes, go on his Minecraft server to talk to his buddies about what his homework assignment was, because they got voice chat on their Minecraft server. Go Minecraft, yeah. Huh? Yeah. So, I don't know. I don't know what the obsession is with voice, except for... I get it. I get it economically, but...
No. The voice, I'm sorry to interrupt, and I don't have this on a slide, but the orange is data in the U.S., and the little green dot in the middle, that little green dot is PSTN voice.
But let me
voice for the data.
Let me answer my own question, because if I don't answer my question, someone else will. The obsession with voice is the obsession with universal connectivity, right? That's the obsession, right. is the obsession with universal connectivity, and the notion that it's a problem if you can't reach however you want to reach. And we use the language of voices because that's what we've lived with these past whatever years, but it's not what we mean when we have it. Well, so I don't want to speak for anyone.
There is and let me hopefully set the stage for your points, but if not,
I'll be impressed if you can guess them.
I'm the moderator. So we did live in a world with strong interconnection mandates on the PSTN. We do know that world and the problems that were associated with it, as well as some great successes, by the way. And Mark, I think, really talks in his paper and in his presentation about that those requirements did get us someplace, particularly toward closer to universal service. But you also did create, with strong interconnection, terminating access monopoly issues that, paradoxically, it wasn't the big guy that benefits from terminating access monopolies. As anyone who knows phantom traffic and traffic pumping, it's the little guy who does amazingly well in a strong interconnection world without regulation.
Some of them suffer, but some of them.
So looking toward an IP interconnection world, what are the lessons we do take away from the strong interconnection norm that we have on the PSTN? And Zac, I hope I set you up to say something.
So I'll try to come back to that. The 2 points I was going to make before it were, one, when you look at interconnection, we've talked about the Open Internet Order, and we've talked about Jim and Mark's proposed rules, but there's a pretty rich legal backdrop against which this conversation is being had. First, and most importantly, Congress's pronouncements in the 34 Act and the 96 Act, which the FCC is tasked with implementing and serving. And so you look at those and you look at rules that have been promulgated pursuant to those congressional mandates. Things like the data roaming order that the Commission adopted a couple years ago and that the DC Circuit just recently upheld. That's a form of interconnection, although it may not be typically understood as such, that allows carriers, or rather customers of a particular carrier, to know that their carrier is going to negotiate with another carrier so that they can roam across networks, pro-consumer, pro-competition benefits. Similarly, on the voice side, we've talked about these TDM obligations, which continue under Section 251 and the implementing rules. I guess one of the lessons from the voice process, and in particular things like phantom traffic and traffic pumping, are the need for regulators implementing Congress's directives to stay abreast of these rapidly changing technological and market forces. So with phantom traffic and traffic pumping, for those who don't know, these are fundamentally arbitrage schemes that took advantage, or take advantage, they persist to some extent, of these regulated payments in the inter-carrier comp system. In the case of phantom traffic, some carriers would mask traffic, so they didn't have to pay the terminating carrier the rates that terminating carrier was owed. In the case of traffic pumping, some carriers would generate traffic without any real communications purpose, simply to collect those fees. And the fact that those problems over the course of a decade grew to the size they grew to, I think, is a reminder that as we move forward, we need to keep close eyes on the technology and market evolutions and be ready to adjust our rules as appropriate to address those where we risk these very pervasive distortions taking hold.
Two observations. Jim's discussion of voice is exactly right. If you look at the key provisions of the Act as amended, none of the public interest principles has the word voice in it. They're all telecommunications. And for me, that's the legal basis that he actually has the authority to do this, and we'll litigate that for another 4 or 5 years. So it is actually the case. It's all about telecommunications. It's not about voice or data, and Congress made it absolutely clear that information services and advanced telecommunication services were swept into that definition, and it was the FCC who got it wrong, and now the courts have been scratching their heads for a decade. We'll see if we can straighten them out. The second observation is really interesting. Over the history of this stuff, there's kind of a 50-year rule. That is, if you look if you look at the license spectrum, and if you look at common carrier regulation telecommunications, at the time those decisions were made, they made perfectly good sense given the technologies of the day. And they continue to make good sense for about 50 years. And then, of course, the technology changes and they don't make any sense, but it takes 50 years to get rid of them. And so that's why I call the 100-year mistake, right? And so I would love not to have this debate, but we're going to have it. And I submit the answers: A, do no harm, but also we need to expand this space. And it takes the good faith effort of both sides to actually get the state to do a few things right and get out of the way.
I like get out of the way.
Well, that's right, but you don't like to do things right.
You're not going to like the preamble.
I mean, I think Jim's point about voice and this focus on voice about universal connectivity goes to my concern that means the rules won't be limited to voice. They're going to go beyond voice. And Mark, I hear what you're saying about the Act, but the reality is the 96 Act talks in terms of LECs and ILECs and IXCs and interconnecting and exchanges, and all those things are going away. That's not what it's about. And the concern I've got with the rules is the unintended consequences. It's just very hard. And look, this commission has done an enormous amount in reforming inter-carrier compensation. It's been talked about for more than a decade, and it didn't get done until now. Now we're on a glide path. But it's incredibly difficult for regulators to keep up with evolving technology and be able to regulate effectively, so you end up with a world of unintended consequences that impede innovation. And that's the concern, but I think we all agree, interconnection is important. It's how do we get there? How do we best get there? And our view is the market's driving us there, and we have about 20 years of experience suggesting we can rely on that.
Let's go to the audience for questions. Students going first. Yes.
There, Mike?
Yeah, we'll make it through.
Hi, my name is Alex Kryline, and I'm a first-year student with the Interdisciplinary Telecommunications Program. I had a question for the panelists from AT&T and Comcast. I'm a little confused insofar as both of you seem to be advocating that at some point that there's a possibility that there should be interconnection requirements for voice over IP, or at least you both agreed when Zac said it. But my question was, it's not like you guys are building two different networks, one for voice and one for data. And I'm unclear at the point at which you find that it is acceptable, like what a time scale looks like for that interconnection requirement. Because that's the same type of requirement that I found very interesting in the net neutrality debate of we should have an open internet wired, but wireless will find out whether or not this is something that breaks down and we need to have a regulatory regime around it. I find it somewhat specious.
So I'll go first because I think we have a slightly more in the middle position on this. I don't think Comcast is saying there should be regulation for IP voice interconnection. I think we've just said, why are we rushing to regulate this when you're taking something from the PSTN into a very, very different network that has worked very well? We're not saying you won't need it. I mean, I just think we're saying, why don't we see how it's supposed to work and what makes sense before you start assuming ahead of time that regulation is necessary. And so that's what we've said with respect to that. But I will say this, because there has always been this fear that the FCC is going to regulate, There is, and I think historically, IP voice interconnection has happened on a technically different set of paths than the rest of our internet connection. We could take a lot of IP voice right now and just exchange it over the internet, just on regular data connections, and we're not doing it. And we're not doing it in part because we go exactly where Len's saying. Then you just immediately, if the FCC says, I want to regulate voice interconnection and IP, go into regulating all data peering connections, which we think is a terrible idea. So it is a situation where you do have this threat of FCC regulation, or the possibility of FCC regulation, which is going to freeze in time current technological architecture that is in many, many cases going to be totally inefficient.
Yeah, let me add to that. I want to be very clear. I am not conceding that there should now or in the future be regulation of VoIP interconnection. That is not what I intended to say. What I intend to mean is, if you go there, I agree with you entirely. What's the difference between a VoIP packet and every other packet? And the risk I'm trying to highlight is regulation of VoIP will inevitably lead to regulation of interconnection for all data. So you end up, this is the 21st century Pac-Man enveloping the internet in regulation. And I don't think anyone in the room is ready to concede that.
So there's a tendency, I think, maybe bolstered by this panel, to think that large players, the largest carriers, are reflexively opposed to regulation, particularly around interconnection. And smaller carriers or consumer advocates or government regulators are supportive. One of the things that happened in the interconnection space over the last couple of years was Time Warner Cable, one of the very biggest communication providers in the country, filed a petition with the FCC claiming that they were being discriminated against in Maine, where some of the rural carriers in that area weren't allowing interconnection. And that meant practically that Time Warner Cable couldn't enter and provide a voice service. For them, it would have been a voice over IP service to combine with their broadband service and their video service to be a triple threat in that market. And the FCC, in fact, after looking at the law and the facts, issued a declaratory ruling saying that Time Warner Cable and others in that posture could, in fact, have the benefits of a particular provision of Section 251. But there's complexity and there's nuance in these interconnection disputes, and I didn't want that to be lost in this discussion.
Students? Any other students? Seeing none, I'm going to go to John Nectarline, who's a student at heart and spirit.
So Jim Speta said something that makes me think of the future of this debate, and the observation you make about your teenager. I also have a teenager, and it turns out that we've had sort of a new kind of Negroponte switch in which young people today talk on their laptops and write on their phones.
Yes.
And when they're talking on their laptops, they're doing it via over-the-top services. And over-the-top services are increasingly popular. It's unclear to me that you will need to have managed voice services for ordinary consumer applications. There may be a variety in business and other contexts where people want to pay for managed service. But ultimately, probably the majority of voice in the world will be over the top. And in that environment, I hear you, Jim, when you say that we should be concerned about universal connectivity. There should be a way to reach everyone else that has E911 dimensions, it has public safety, other forms of public safety dimensions, and I completely agree with you. The question, though, is in a world that is converged, where voice is an application, riding on top, like other data applications, riding on top of networks, and where voice is exchanged to the same peering points as other data applications. In that world, are we really talking about interconnection obligations, or are we talking about an enum solution combined with interoperability requirements? It seems to me that on some level, this is not your grandfather's Communications Act issue anymore. This is not about physical layer interconnection. This is about interoperability and enum solutions so that everybody has a way of finding everybody else. That wasn't really a question.
Then I won't really give you an answer.
Well said.
I don't disagree with you. I don't. And that's why I'm I won't confess again about the error about NPD. When we start talking about the need for people to reach each other for things that matter, E911 is probably the greatest example. And you know, I think Mike Powell gave a speech here about this. You know, why are we not? You know, we're talking about apps and interoperability, but we've got to consider the legacy public too, right? We're not going to cut my Aunt Rose off just because she's not going to get an iPhone to call to tap 911 service, right? So I don't disagree with your premise there.
That's a time-limited problem.
Hmm?
It's a time-limited generational problem.
Yeah, my Aunt Rose
really
has been around for a long time.
So's Mom. Mom's 89, but it's still.
I agree with. I agree.
You know, we're.
Mark Lemley.
So
You're going to ask a question, right?
I am going to ask.
Okay.
She has a mobile phone.
And it's mostly directed to Leslie, although, or at least inspired by Leslie. You know, at this conference over the past decade or so, we've had enormous conversation about layers. And what's remarkable to me so far today is the almost complete absence of any discussion of layers, particularly on a panel here, which seems to me to be making assumptions about regulation that come precisely at the layer level, right? So the only one who speaks to that question, I think, on this panel is Leslie, and she says, well, hey, I've got a conflict because I know historically, if we don't have a non-discrimination rule, people are going to take advantage of it, they're going to discriminate. But how do I get an effective non-discrimination rule if people are just going to move things up the layer to the applications layer? My question is, why do we care? Right? Why isn't the right rule have a physical transport non-discrimination rule that's true whether it's voice or data or anything else? And if the result is people move something up to the applications layer, isn't that a good thing? Don't we want that?
Oh, I was saying I don't want to move regulation up to the.
Well, but why? Right? So why not be satisfied with a world that says physical interchange transport has got to be done on an interconnection basis? And if you can build a program on top of that that moves things up to the application layer, good for you.
I definitely talked about infrastructure network industries. So I was talking about that physical layer.
Right.
And I also believe that by allowing the internet to ride on that layer without interference is why it succeeded. And that's what I want to preserve. And people keep telling me, well, there's the inevitable Pac-Man. And, you know, Jim Speta says, I don't even have ancillary authority. And you're telling me I'm going to find some authority to reach into the upper layer and regulate the content. It ain't going to happen. I don't worry about that part of it. I worry about this physical part. So your Pac-Man is maybe your nightmare, but boy, it's got no basis in reality.
But no, because you won't be satisfied. People who talk about an interconnection obligation will soon argue Skype, AT&T, Comcast together maybe have 800 million VoIP customers. And how is everyone else going to compete unless we interconnect, and there will be efforts to reach that? That is the problem. It's the unintended consequence and the inevitable incrementalism of regulation.
My problem is I can't even reach the physical layer with my legal authority, and you're telling me I got to worry about efforts to reach higher up? I'm not going to lose any sleep over that, even though I'm not going to be in your nightmare, for sure.
Oh, Mark, you already are.
No,
I'm trying.
Yes.
I'm trying. Yeah, I mean, look, I do see a difference between the network layer and the content layer, the application layer. I don't know how you start down the road, particularly at things like VoIP, and draw that line. I do think that's where we get our innovation. I can't figure out how you reach in to something like VoIP and don't start exploding it. And I continue to be worried, as I said at the beginning, which is why I think that was Phil's joke to put me on this panel, because he knows that I'm completely conflicted about this. You know, I can't, you know, when we're facing things that I expect to see in Washington, like CALEA mandates for, you know, I mean, I think we're going to fight them this year, and it's going to be specifically aimed at communications capabilities at the application layer. I know this is coming, and so I'm already in the nightmare that Mark doesn't believe is going to happen. And so I am concerned about sort of how we draw the line knowing that drawing the line may not make real sense if we're really talking about.
And I would add, I mean, I think part of the answer
That's why I'm
maybe,
struggling.
Mark, is why Len's slippery slope is possible is if you think about CALIA and public safety going up the stack, is going...
Think about the CVAA, right? Think
Yeah.
about Congress's decision a couple of years ago to impose these disability-related obligations that go well beyond traditional network operators to device manufacturers, to services and applications.
Yeah.
We're in the world. I mean, it's not as if
I
this
think
is
it's
some
something to be
distant...
concerned about. Yes, one more question.
Sure, Steve Schultz from Princeton. And my comment is mostly to Jim, although the panel may want to address it. First of all, Jim, you got to get that paper out because I'm about to cite your 2002 paper. If you're recanting everything, I don't want to be citing that paper. So, all right, the pressure's on. So you say denials, interconnection denials in the past have been rare. I wonder if that's because of the threat of regulatory overhang that Lynn was talking about. I also have a problem with this notion that traffic is going to be able to route around any of these interconnection problems because interconnection is not necessarily binary. As we saw in the level 3 issue, the level 3 Comcast dispute, there were questions about the quality of different links, whether or not the traffic was being routed over saturated Tata links or whatever they were doing. So things become very complex at that point. I think the Clark paper, which I have also read, is right to say we need more information, but they say that they don't say clearly we don't need regulation now. They do say we need more information. So I don't think that paper stands for no regulation in the interconnection space. But finally, I guess most significantly, I was thrilled to hear from Lynn that she thinks that terminating access monopoly and duopoly is a real thing, and that the open internet rule is an important safeguard. I
can't wait to read the tweets.
Yeah.
I'm going to guess
I would
that
love
not
to
just
hear your
Jim
comments on
has to
that.
answer this question.
Okay, so many places I could begin on this. No, I actually think that given all those transit links, there is no terminating access monopoly. In fact, I think the problem really runs off in the other way because the only way the access providers can get a lot of the traffic they need is from entities that have absolutely no obligation to interconnect with us. But as I said, there are 38 routes, 38 transit routes in the network, and these routes that you suggest may not give as good quality are, some of our transit routes are AT&T. I really don't think there's a problem there. And a lot of the traffic that was at issue with level 3 used to not come to us directly and then moved onto that route, so would have just gone right back to the other routes, which in fact in many cases
more facts.
it
Now
did.
all
So
kinds of
no, I
facts.
think we actually really think on the internet it's just a fallacy, and it's just an idea from the PSTN that people cannot get out of their heads. But it is such a different network, and the sources of power on that network are so incredibly different. We, as an access provider, are sitting there with content providers or CDNs who can cause incredible pain, shifting traffic around, putting things on either the most expensive possible route they can get so that we use the most backbone resources possible that makes our deal with them incredibly expensive for us so that we will cave and give them a better deal. They can route traffic onto our most expensive paid transit routes that we pay on. Okay, so that when you're talking about congested transit routes, those are routes that we're paying someone else to put up. And we have no control over whether those get congested because content providers can dynamically route on to that transit route. And the minute we put a little bit more put a little bit more there and pay a little bit more, it can congest again within seconds, microseconds, because what they're doing is sensing where is there an access route on anywhere on the network, and that is how they're going to get traffic to us. We have no control over that. We just take that traffic, but we're paying for it. So there are so many complicated relationships on the internet that are absolutely have no duplicate on the PSTN, that to sit there and think you know how it works because we control the customer. So we're an access monopoly. It's just wrong. You need to understand these networks better. And by the way, most of us, certainly those of us who are bigger, we're paying to get traffic off our networks just as much. And in fact, in Comcast's case, we have a complete balance in and out. We are a transit provider to others. So we are sending traffic off our network all the time trying to seek our own links, trying to have relationships that are going to work in bilateral ways. We are not just taking traffic in. And then just to add another complicating factor, all the smaller ISPs, who also are terminating monopolies, are paying through the nose to transit providers so that they can get onto the internet. They're not blocking traffic, they're desperately having to pay for traffic. So it is so much more complicated, and you cannot come to the internet with a PSTN mindset and think you are going to regulate in an intelligent way. And by the way, the regulatory overhang I was talking about was solely in voice. The internet has been free of regulation. The FCC has been consistent for over 2 decades, more than that they were not going to regulate the internet backbone. So all of this interconnection has taken place with no threat of regulatory overhang other than the past few months.
Well, I see
That's
things
more
a little bit
facts, more facts on the table,
So,
or at least a certain facts.
For 15 seconds, Zach, and then Jim.
Try to keep it to 15 seconds.
Well,
It's true,
well,
but then you get to
no,
clean up. It's the best position to be in. Very quickly, and in response in part to some of the things Lynn said, I think over the last 10 or 15 years, you've seen two very different trends in terms of market power and last mile connectivity. On the voice side, you've seen an explosion of options from cable companies, wireless, and over the top. On the internet service provider side, you've gone from a place with hundreds or thousands of ISPs running over a dial-up access platform to a place with 0, 1, or 2 for high-capacity broadband. And I think the challenges that presents, which feed into interconnection and non-discrimination and public safety and universal service, are the ones that we're grappling with.
Professor Speta, you're going to get the last word.
The question about regulatory overhang is a wonderful but non-false. The thing I tried to do is to say that there's some solid economics done by people who are economists, not me, and some solid engineering done by people who are engineers, not me, who suggest that there are real reasons to worry about interconnectivity. I might be wrong. I'm not in the business. I go to an awful lot of seminars, and I think most of the people have a deep understanding of at least the basics of what's going on. But if somebody like David Clark can say, there's an issue here that we need to know more about, fine. We need to know more about it. I've been going to conferences for 13 years where we've been told we don't understand how things work.
And it's still true.
And they work pretty well. Let's be clear. In the last 13 years, every mobile device in everybody's pocket didn't exist 13 years ago. And so, as bad as you guys think they have done, this is a pretty good space.
Well, as usual, Mark Cooper does get the last
Absolutely.
word.
Therefore, we should
I want to thank our panel.